Oh yeah, I'll give it a go. Tell you what happened, I'll give it a go. So I was up Servo, getting a few bevies for a barbie I was having this afternoon with a few of my mates. Next minute, old mate, he's reversed out, bit of a love tap. Next minute, swap some details, and then he's off, doing the Bundy. Well, just like real life, all industries have jargon. Some familiar, some unfamiliar. If you've been involved in a motor vehicle accident that wasn't your fault, you might encounter some of this terminology, and whilst not a comprehensive list, let's take a look at some very common phrases that might help you make the experience a little bit more understandable. Shall we? Hi, thanks for stopping by. As always, I'm Kashmir Z, here talking about claims. Terminology in the insurance industry can seem a little bit confusing. You might wonder why the words actually have the meaning that they do, or the vocab that they do. The reason that is because most words and phrases and terminology in the insurance industry, or even adjunctions to the insurance industry, so credit hire industry even for example, are usually derived out of legal terms. And like most legal terms, I'm sure solicitors and anyone involved in the legal industry would advise and probably confer, doesn't necessarily come up in day-to-day conversation in ways that normal people would probably understand them. So this is not a comprehensive list, it's just a random assortment of words that I plucked off the top of my head in no particular order or importance. But first on the list, I would probably state contractual liability. You've probably lived most of your life and go about your life never wondering about the word liability, let alone what contractual liability actually means. Contractual liability basically means that you are bound to a bill or an outcome for the duration of the specifics of the contract. Basically, read your contracts, people. I don't care whether it's a bloody motor vehicle accident or some sort of legal arrangement or an artistic contract. Always read your contracts. And if you don't understand them, have a solicitor look at your contracts for you. That's contractual liability. Yeah. A very funny one that we have in the insurance industry that I guarantee you most insurers and people in credit hire that work at a claims level or even a recoveries level probably never encounter, because very few people use it in Australia. Impecuniosity. Yeah? Not even trying pronouncing that correctly. Impecuniosity. I must admit to you, at least 4.5 years in the industry before I even heard this term. And when I Googled it, I laughed because it comes up an example of a beggar and blah, 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 blah. Just a funny little Google images photo. Impecuniosity basically means poor, yeah? But that's pretty harsh to say it that way, or the way that it would be phrased would be the client was impecunious, yes? Meaning they wouldn't have had the funds to pay for their rental car, yeah? So that can be important in different cases, particularly if it's a matter of need that's involved. It's a very interesting term. I don't often at a claims level hear it come up very much, but I'm sure people that work in legal sectors of credit hire companies and even insurance companies probably hear it come up quite a bit. Yes, but that's what impecuniosity means. So if you're contacted by a recoveries agent or you're contacted by a solicitor that works for the insurer or the credit hire company after the fact, and they start asking you about your financials, or they directly ask you, I doubt they're going to ask you, were you impecunious at the time of the incident? But if they're asking you questions about the financials, they're going to argue impecuniosity as part of your case. Yeah, so always be honest if they ask you those questions. Yeah, otherwise you'll make them look like a goose, and that's never good. EBO, common phrase. I think I've made a video about it. You can take a look at it over here or here if I can figure out which side is which on the camera. Basically, it means each bearing costs 50-50. If you're interested, check out that video. It'll give you a bit more detail. Without prejudice, that's an interesting one. So without prejudice, basically, it's not so much a piece of terminology, but rather a phrase that you'll find used in the insurance industry, and I mean that the broad umbrella, which essentially constitutes stating in the absence of any further evidence or in the absence of any evidence that might come to the fore after the fact, basically meaning an insurance company or a credit hire company or whatever will probably use it in the phrase of, without prejudice, liability is majority accepted, subject to quantum. Yeah, quantum. That's an interesting word. Are we talking about James Bond? Isn't that a James Bond film? Pretty sure it was a good film. It's got anything to do with that? No. Quantum is basically the final figure. Okay, so if your bill for the hire car is $5,000, quantum would be the $5,000, which may or may not be paid without prejudice. Yes. Proof of loss. Proof of loss is basically when you collate together all the facts and figures of the actual rental, if we're talking not at fault rental, or damages, if we're talking just insurance claim. So that would be your quotes from, mechanics, that would be your receipts for anything you're claiming, that would be the final figures, etc., all collated together. You put a letter of demand on the top of that, which is basically a strongly requested letter that would indicate payment may have outcomes if not reached. Gosh, that was polite of me, wasn't it? That's what basically a proof of loss is. Subrogation is a topic in and of itself. I probably should talk about that another time, but if you ever hear that the claim has been denied because it was a subrogated claim or a matter of subrogation, that would mean in some degree that there was some sort of conflict of interest. So perhaps if you have two cars, one with insurance company A, one with insurance company B, you back into the car, you claim through insurance company B because that's your insurance on that vehicle. If there's any error, and you try to claim anything else for it, so not a fault rental vehicle or something like that, the claim would be denied because it would be considered a subrogated claim. Basically, you can't sue yourself, yes, and there are other instances where if you have a joint policy with someone else that has a vehicle, it can be challenging to escalate the matter if the insurance company doesn't want to pay for it because you can't issue legal proceedings on the same address. As I said, it probably does require its own video, which I might make at some stage, though I'm not an expert on it. I might need to have a chat with the solicitor first. But subrogation, yes, basically it's denied because it's either a relative or there's some sort of conflict of interest regarding address or policyholder or something like that. Obligations not met, obligations met. Obligations are basically all the things that the individual that holds the policy needs to do for the insurance company to accept or indemnify their client and take the claim on board. Usually, if you hear an insurance company say obligations have been met or obligations have not been met, they're usually talking about the excess. Sometimes, if it's not yet finalized, they might be requesting a version of diagram or some photos or something like that. But I would go as far to say 7 times out of 10, they're just talking about the excess. So if you're wondering what are obligations, that's what obligations are. Indemnification is will they represent. So in certain instances, the insurance company will want to make sure that they will indemnify their client. That's just a fancy legal word that means will they represent their client, meaning will they accept the claim? Will they follow through on the matter? That's what indemnification is. It can be denied for a variety of reasons, and that is you could probably write a book, okay, on indemnification. I'm quite sure there are legal people out there on YouTube that have. Look them up. Maybe they can recommend a few to you. But indemnification in a buzzword basically means will the insurance company represent the party that has made the claim. And there we have an assortment, a random assortment of industry jargon that you might experience within the insurance industry. I'll leave you with one more. My favorite phrase is liability has now been extinguished. Was it on fire? Did you have to get a fire blanket? Was a fire? Is the liability okay? It's been extinguished. Have we got it to hospital now for burn treatment? No, that just means that the funds have been paid to whatever party for whatever reason, and you don't have to worry about your contractual liability for it anymore, to tie this together to the start. As always, thanks for stopping by. I hope you found this random assortment enjoyable, entertaining, informative, perhaps, question mark? As always, if you could, like, subscribe. If you have any questions, drop some comments down below. But as always, keep safe, drive safe, and have yourself a wonderful day.